See the queue.
Not quite yet. Now we're ready.
So, welcome to the December 4, 2025 meeting of the Public Safety and Sanitation Committee meeting of Community Board 6. I'm Stuart Desser, Chair of the committee. We're joined tonight by Assistant District Manager Brendan Burke. This meeting is called to order at 18:38. Reminder to any committee member attending virtually that you must keep your camera on and your full name displayed. Brendan, I'm doing things a little out of order, so it's time for the roll.
Okay, committee members, I will call your name. When your name is called, please say present. I'll announce if there is quorum. Stu Desser.
Present.
Justin Goldberg, I do not see with us.
He's coming possibly late.
Good. Gloria Haig.
Present.
Rupal Picard.
Here.
Steve Perez.
Present.
And Ann Seligman.
Here.
We have a quorum.
Very good. The agenda for tonight's meeting was distributed ahead of time. It's on the screen before you. If there's no objection, we'll adopt the agenda. If you object, please speak now. Seeing no objections, the agenda is adopted. The minutes from the December 2024 and June and November 2025 meetings were distributed ahead of time. If there are no objections, we'll adopt the minutes as drafted. Committee members, if you object to adopting the minutes as written, please speak up now. And seeing no objections, the minutes from December of last year and June and November this year will be adopted and published on the CB6 website. Board members know the ground rules, so I'm going to save my verbosity for later, which there will be. Without objection, we'll suspend the rules requiring committee members to be recognized before speaking. There will also try to be orderly, obviously. Seeing no objection, the rule is suspended. So those of you who are not sitting at the table, should you have cause to speak, remember that the microphone is that little annoying thing, so you'd have to speak loudly or come closer. And so on to the meeting. The Treatment Court Expansion Act, I'm going to set the stage as I see it. If I get anything wrong, it is your responsibility to make sure I get it right. Same to you, Jeff. I do want to first just point out that you're getting a little bit of extra bang for your buck because members of this committee overlap with other committees. So we have the chair and the vice chair of the Health and Environment Committee, which is very interested in mental health. We have over there the chair of the Budget and Governmental Affairs Committee. We could not have, because he couldn't make it tonight, the chair of the Housing and Homelessness Committee. But this is all of interest to us because we know that there is sort of dependency on housing when we're talking about mental health care. So, we know that's not part of the bill, except for a slight mention. So this is our second meeting to consider the proposed Treatment Court Expansion Act, which aims to increase the range and number of people who are sent to counseling and other treatment instead of being punished if their criminal conduct is credibly attributed to mental illness or drug use. There are two drivers behind this diversion to treatment and away from punishment. One is moral. It's the idea that people in certain mental states are not acting entirely by free will and in some ways are themselves victims of their condition. The other driver is pragmatism. It's about crime reduction. Experience tells us that for people with mental health issues, treatment significantly reduces recidivism and thus lowers the incidence of crime in a way that punishment does not. In fact, imprisonment may exacerbate existing mental health issues and may therefore increase the rate of reoffending. Just for a little context on recidivism, the Department of Justice reports that the average male inmate in state prison had 5 prior incarcerations and 9 lifetime arrests. That's not limited to those with mental health or drug issues, but considering the estimate of how many people have those issues in Rikers, I think we can make a pretty strong inference. At our first meeting, and I do apologize for the bad audio, but we have fixed it now. At our first meeting, we received a presentation by the coalition behind the treatment court bill. Tonight, the primary presenter will be the New York County District Attorney's Office, which agrees with some of the draft provisions. But we note that the general principle of diversion from punishment to treatment is not a very divisive issue. And prosecutors, judges, and lawmakers from across the spectrum generally support diversion. And indeed, our speaker tonight is in charge of the program, the diversion program at the Manhattan DA's office. So I think all parties in this debate agree that diversion is an underutilized means of increasing public safety for everyone and improving lives. Disagreement is not about the principle, but some of the particulars. And I do want to say that distinct from what we see throughout much of our country, all of the parties here are people of goodwill who have been acting collectively for more than a year to try to shape this law into one that everyone is comfortable with. So finally, at our community board, we try to act with reflection and not reflex. That's why we don't substitute our ignorance for your expertise, but rather we listen to experts with diverse opinions. However, once we're provided with facts, whether they're settled or unsettled, and with the underlying logic, it's exactly the province of a community board to weigh and balance the moral and social and political risks and benefits as best we can, and then advocate for what we see as producing the best outcomes for the community as well as for the greater society. So with that, and I should just mention, since you see we're obviously a small portion of the board, certainly community board sits, most of the business is conducted at committee, and we bring it then to the full board, and most of the time the full board validates, adopts our resolution.
Substance.
So, we'll hear first from Tony Martirosian, who's chief, right, of the
Right.
Pathways Division at Manhattan District Attorney's Office. You're also on the board of the Association of the Treatment Court Professionals. From a different viewpoint, we're also joined by legal aid attorney Jeffrey Berman, who specializes in mental health issues. And we welcome Rocio Chanez, the legislative director for Senator Jessica Ramos, who's the primary sponsor of the bill. I haven't named everyone who may be with us, but actually so far I have, so that's good. So it's up to you.
Wonderful. Is there a clicker for the,
Yes, I do.
Okay,
And I
great.
can. And it's already on.
Great.
Just need to share the presentation on screen.
okay,
I will in just a moment.
okay. So I'll jump in and just say thank you so much for the opportunity to come and speak today. I was able to listen to Casey's presentation from November, and I know Casey and Jeff very, very well. You know, I consider Jeff a personal friend. I have a lot of respect for the work that he does for many of the participants in our treatment courts. I also see Danielle Mendez from Midtown Community Justice Center. She is a wonderful partner in the work as well. I really appreciated during the presentation. It was a little hard to hear, but I was able to lean in and make most of it out. And I appreciated questions about, well, what would, how, kind of to play devil's advocate, like how would people disagree with that? You know, and I really encourage that today. Obviously, you know, I've dedicated my professional life to treatment courts. I believe in them very, very deeply. And also, you know, have seen what harm can do in community and the trauma it can cause. And so I'm also very committed to community safety. I just want to take a minute and introduce two of our Pathways Division members who were very eager. We really enjoy going into community and sharing what we do. There's a lot of misinformation out there. And so this is Shawnee Davidowitz and Monica Nejitim, who have been in Pathways for, actually Shawnee fairly new, Monica for longer. Monica was actually a defense attorney for about a decade before she came over to Pathways. And Shawnee has done many things, but primarily as a lawyer, she's been a prosecutor. So we're so happy to be here, and I encourage them, if I left something out, to try to jump in. Let me just give you a little background on myself so you know who's speaking to you and what my experience has been. I actually, before I went to law school, was a New York City public school teacher. I taught fourth grade at Public School 48 in Hunts Point in the South Bronx. I always mention that because, you know, at that time, and probably still today, that was part of the poorest congressional district in the country. The intersection between poverty and the criminal legal system is
Yeah.
significant. Um, my work as a teacher impacts every day, the work that I do in the courtroom. It really informs, I think, in a powerful and beautiful way, much of my work in pathways. And so I always share that is a huge part of my background and hardest job in the world. I went to law school after leaving teaching, and then I have been at the DA's office since 2007, my entire legal career. I spent the first number of years as a trial attorney, first prosecutor, first misdemeanors, and then eventually felonies. Prosecuted all sorts of cases: sex crimes, domestic violence, identity theft, much more serious gunpoint robberies, firearm possession, and eventually I would cadet on the homicide chart, which meant that I would support the lead homicide ADA going out to crime scenes and presenting those cases to grand juries and even trying a few. In 2013, I had the opportunity to join, it wasn't even a unit then, it was just drug court, but it wasn't a unit, it certainly wasn't a division, which at the DA's office is much bigger than a unit. And it was really Article 216, which is the legislation which the Treatment Court Expansion Act aims to revise and expand. It was passed in 2009. Casey got into that a little bit. So in 2013, we were still really building out the drug court, and it was a pleasure to witness that and to be part of those early days. In 2015, then DA Cy Vance asked my colleague and I, actually two of my colleagues and I, to not fully step away from the practice, but to really spend a year familiarizing ourselves with every aspect of everything from best practices in treatment courts to the homeless system. And we literally went on tours of shelters from start to finish, from Bellevue shelter, where most men enter in Manhattan, to the kind of the satellite shelters. We got to see that. We got to meet with a lot of teams that are on the ground with mental health issues, Kendra's Law, assisted outpatient treatment, all sorts of things. We visited supportive housing. We visited then, and I still make it our practice in Pathways today to visit treatment programs regularly because we are sending people there. We need to know where they are going and what sort of quality of care they are getting. So after that year, and we went deeper than substance use and mental health, sex offender behavior treatment programs, workforce development treatment programs. We really took an inventory as much as we could of the entire landscape in New York City and even beyond. And then we came back and started the first ever at the DA's office, Alternatives to Incarceration unit. It was a pretty small unit, couple ADAs, couple professional staff members. But it was the beginning of really a significant change at our office in that we began to consolidate all of the felony treatment dispositions that were happening outside of formal treatment courts. And we worked very closely with the Office of Court Administration to launch a first of its kind felony alternatives to incarceration court part, which launched just before the pandemic in 2020. I was also part of the, meetings and advocacy around getting the then DA Cy Vance to contribute millions of dollars to stand that court up. It was, again, it's been an incredible experience. And in 2022, when Alvin Bragg was elected DA, he took what was a very small unit within our larger trial division, and he created the Pathways to Public Safety division. I started out as the deputy chief of that division, and I'm going to talk tonight a little bit about that division in more detail. And then about a year and a half ago, I was asked to be chief of the division. So
Can I interrupt for 1 sec and ask a question?
Of course.
You just raised a question that makes me think about like where the money for this comes from. Like county, DA is a county position, but obviously part of a bigger city, part of a bigger state, which often has laws that are like, these laws apply to cities of greater than 1 million people. So I'm just you don't have to answer this question now, but keep it in mind as you go forward.
I will.
Kind of where the funding.
I will absolutely do that. So, and if I forget, then please remind me, but I will because I touch on funding actually in the presentation. So let me jump in. This was the agenda I was hoping to cover today, an overview of our division, which I already got into a little bit, some relevant data. You know, people really want to see data. And one of the things that consolidating and really organizing our work in the way that we have been able to at the DA's office, it's enabled us to try to track a lot. We can't track as much as we really want to, but in my experience, I speak on a lot of panels. I think we're doing more around data collection than probably any other DA's office in the country. So we're very proud about that. I want to touch on the common grounds in terms of things that, as someone who's done this work for over a decade, I think are wonderful in the Treatment Court Expansion Act, support wholeheartedly. There's a lot of common ground, so I want to start there. I also think it's really important that we talk a little bit about like Treatment Courts 101, because some of the concerns I have are related to what we know about best practices in treatment courts. Treatment courts have been studied, they are evidence-based, and it's important to just have a little overview of what treatment courts are and what they are not. Then I'd like to touch a little bit on treatment court dispositions currently in Manhattan. I know Casey put up some of the different treatment courts that we have, and I really want to talk in a different way about that work. It is so important that I share, and I'm so happy to hear that many of you are on other related committees, because there are many current challenges that we are experiencing day in and day out in our treatment courts. And it's important to raise alarm bells about that independent of this legislation. I would love to see folks in power doing more to try to help address some of those challenges. Then I would like to touch on the concerns about certain provisions that I have in the Treatment Court Expansion Act. And then, of course, really hope that you'll ask questions.
Don't worry.
Okay, and I'm sorry that this is, oh, you know what, is this? I think we have slightly different PowerPoints. Do you know if maybe this might be the older version?
This is the newer version.
Oh, maybe I have the older version, which is actually fine, because I have kind of additional notes. All right, I apologize.
You can wait.
Okay, and there's so much on the page, and I know that's like a bad habit with PowerPoints, but I also just wanted it to be there for all of us.
In essence, it is the same, just some of the language is slow.
Okay, all right, so,
And there's a lot of words there, so I'm gonna do more listening.
okay, I think, and this is almost more to remind me about, I just wanted to make sure that I didn't forget anything. So, all right, the division. I told you it was created in 2022 when DA Bragg took office. I think that people who aren't familiar with structure at the DA's office wouldn't necessarily understand what a big deal it is to have created a division that is on par with our trial division, our appeals division, and our special victims division, dedicated solely to these sorts of treatment dispositions. I should also just mention our division oversees a lot of related work streams. We have a neighborhood and court-based navigator program that is tremendous. They are doing, our navigators, amazing work. Really not with individuals who have, cases and are trying to engage in treatment to kind of resolve a case. They are our neighborhood navigators on the streets every day, approaching people. I've often heard DA Bragg say, the folks that others walk on the other side of the sidewalk to maybe avoid, our navigators approach. These are people who tend to be unhoused, living with serious mental illness and substance use disorders. They are relentlessly engaging with them with the goal of trying to meet their needs, everything from shoes and food to eventually trying to get some to be more receptive to care. Our court-based navigators are doing similar things, but for people who are leaving arraignments and not having bail set, and trying to refer them to everything from emergency housing to referrals to community-based providers. We also have a very robust reentry work stream. I actually just tonight was we have a reentry advisory council that meets once a month. These are folks who have lived experience. Many of them have spent over a decade in prison, and they advise us on the impact that different policies have on people with lived experience and what we can do to better support people coming home, because the recidivism rates, as you mentioned at the top, are very, very concerning. We should all be examining our, both Rikers, but also our state prison system and what is going on there and why people who are coming home are so ill-equipped and ill-supported to do better. You know, I think that, of course, the dream is one day we will not need jails and prisons. I think that that is realistically very far off, and we shouldn't ignore the human beings who are in prison. You know, a lot of Casey's presentation was on the ills of Rikers. We have city and state representatives who can do something about that. And I know that everyone wants to close Rikers, but we can't ignore the people who are there. And there needs to be some investment until it's closed to make sure that you know, things are not as they are right now. One of the things that Pathways did that was very significant in 2022 is we hired deputy bureau chiefs, which report up to Pathways leadership, but they sit in our trial bureaus. And they're responsible within 48 hours of someone being arraigned. So if you've gotten arrested on a felony, you've gone before a judge, either bail has been set or you've been released. Within 48 hours of that arraignment, our deputies are responsible for screening every felony. And when they screen the felonies, they are looking through a lens of treatment. They are trained by us. They are ADAs, and again, they're leaders in the office who work every day in treatment courts. So they know what the treatment landscape is. They know a lot about behavioral health needs and criminogenic needs that I think a lot of prosecutors were really trying to educate kind of the mass, but they have a specific knowledge that makes them very well suited for at this very early stage, trying to move cases that are appropriate into treatment court dispositions. I can talk a little bit more about that practice, but it has been significant. Again, I don't know any other DA's office that is doing it. And it is one of the reasons you're gonna see the referrals to all of our problem-solving courts have gone up exponentially. The division, as I said, we try to train everyone in the office, but we are weekly, if not multiple times a week, training our staff on everything from, you know, trauma-informed care to best practices in terms of, you know, substance use and mental health practice, problem-solving court best practice. These are things that are an ongoing conversation in the division. And as I mentioned, we are constantly going into community and speaking to practitioners about the gaps that they're seeing and also observing them for ourselves and also seeing the amazing work that's going on in the community. The division went from, again, this very small unit with a handful of ADAs and professional staff to a division of 50 people. We have 25 ADAs and we have 25 professional staff members. One of the very significant things we've done as a division is we have implemented an individualized review of every person in Manhattan who was given a desk appearance ticket. I think some of you may have heard about DATs. These are by law, certain people, you know, and there is some discretion on the part of NYPD, but instead of having to be put in handcuffs and taken downtown for the night to see a judge, they're given a ticket and told, come like 20 days down the road, come to your arraignment. It used to be a fairly standardized practice, like it was standardized based on charge. Now, someone is looking at every one of those cases with an individualized view of whether or not, you know, this person based on charge and criminal history may be appropriate for a different disposition than kind of coming to court and going through arraignment.
Send him to Rikers.
And exactly, and the usual process, okay? So, and I don't even say usual, because it's not usual anymore. Like, I hate the idea of like alternatives to incarceration, because we are trying to define it as that should be the normal and the exception should be incarceration. We have invested, we meaning the DA's office, has invested millions of dollars in expanding treatment courts and advocating for our other partners and agencies that we work with to expand their investment in our treatment courts. We have seen a dramatic increase in both felony and misdemeanor problem-solving court referrals. I mentioned the individualized review of DATs. And Danielle is very familiar with our DAT practice, so she will speak up if any of this is off compared to her numbers. But 3,185 Manhattan DATs returnable in 2024 completed Project Reset, which is and we can talk about it, It's a program that basically diverts, it's a very, I would call it light touch program that diverts people entirely from the system. You never even have to get arraigned by a judge if you complete this program. We have worked with our partners to develop kind of a companion program for people who we can't reach in advance of the arraignment. They have an opportunity to, before they're arraigned by a judge, when they show up for that arraignment, to participate in this programming. And the DA's office declines to prosecute the case. They never even have to go before a judge. So we went from 922 people reached to over 3,000. That's a 245% increase. And I really do give a tremendous amount of credit to the Midtown Community Justice Center and to all of the partners who helped make that possible. These are people who avoid any further contact with the system because they are being, again, individually reviewed and diverted. We just in April worked with the court system and our defense partners to launch this misdemeanor ATI part. We're going to talk a little more about it, but that part just from April already has 110 people and a total of 289 cases pending in it. Very significant. Our referral.
Wait, so people have an average of more than 2 cases?
There are many people. One of the things that I think, and actually you touched on it a little, and you'll tell me, and Jeff will speak up if any of this is not his experience, but it is, I would say, much more common than people realize. In fact, it is, I think, the default that most people who we see in our system, especially in our felony problem-solving courts, have exceptionally long criminal histories. It is very rare.
So they're not, they're pending, but they're
Many
maybe
people
not,
have 2 cases or 3 cases. We
but they're
see
present cases.
present cases. So like this example, you have 110 people, but many of them have more cases. And so there's almost 300 cases in that part. And I'll tell you, in our felony.
Individual offenses.
Individual
Individual
offenses
charge.
charged separately.
Charged
So
separately.
exactly. So, and in our felony
But
practice,
it could be one instance that has multiple.
usually that would count as one case. So if you get arrested, for the same like course of conduct, it's usually charged in one complaint. So that would be one case. If you have like 2 assault cases or 3 assault cases with not even, it's usually different arrests, because sometimes if you're getting arrested and you assaulted 2 people, that would be one complaint. But if you have multiple cases, it's usually because there have been multiple arrests.
So it's different incidents.
Different
Yeah.
incidents,
Hmm,
exactly.
interesting.
You're gonna hear maybe people who have multiple indictments. That's because there was a felony, it was presented to the grand jury and indicted, and now there's a second incident, felony, that gets indicted, so multiple indictments. In
So
some of, oh, go ahead.
Number of cases is not deterring them potentially.
Well, that's like,
I guess you're maybe gonna go
Yeah,
into that.
look, and give me, yes,
Yeah, go
okay,
ahead, go
there's
ahead.
a lot going on, and as you know, and this is not necessarily a critique, it's just what it is, because of bail reform, people are out in community, and often, they're out in community and not engaged in
Right.
services that they need to interrupt that cycle, and there's a lot of reasons they're not engaged in those services, and one of the reasons, because I think some proponents of this legislation would say, well, you all are taking too long, to get them into treatment, but here's the reality, and I really want to talk to you about this, and it's complicated if you don't practice in these courts every day, but it's very important for people to understand that it is rare in my experience, and again, there are multiple people who can speak up if they disagree, but most of the folks that we see, maybe not in this like pre-arraignment, like those people tend to be a little bit lower needs, they're getting a DAT for a reason, but focusing, for example, on the felony practice or on this ATIM practice, it is incredibly rare that someone has not previously been offered treatment before. We see many folks who have cycled in and out of the psychiatric emergency room, and upon discharge, they are given a discharge plan. We're all given a discharge plan when we go to an emergency room. Follow up with your ENT. In their cases, it's often like go to the Nathaniel Clinic or follow up with the Bellevue Clinic or whatever the case may be. Many of the folks we see have been on probation or parole before, and one of the reasons that's significant is probation and parole, one of their jobs is supposed to be referring folks to treatment providers who can meet the needs that, you know, assessments tell them they have. So the population that we deal with in a lot of our problem-solving courts are not folks who are at a place in their lives to necessarily voluntarily engage in the services that they need. It's just important to set many of them, and it's interesting, in my role in Pathways, I actually have the opportunity to often speak to defendants' family members. They will reach out because many of them have struggled for years to get their
Yeah.
child help and to navigate a very complicated mental health system that they feel is not, you know, I've heard time and time again, and I'm sure Jeff has too, actually, because he works with the same population I work with. You know, I tried to, they released my son. I told them, don't release my son from the hospital. He's going to, you know, go back to using, he's going to go off his meds again, and they still released him. Now, a lot of that has to do with civil laws, and I'm not here to talk about that
Well,
today.
Finances.
And finances, although again, most of the people we work with, probably 95% are on Medicaid. So the same services that we offer them when they are in our program are services that they could have accessed because they have active Medicaid before. And again, it's complicated and we're gonna talk about it, but I just wanna mention, because this is a wonderful stat that we're very proud of. Some courts saw as much as a 350% increase in referrals since 2022. In our felony court parts. And we have seen a reduction, and I really credit our deputies because they are getting eyes on these cases so early. We have seen a reduction in time from arrest to problem-solving court disposition. This is very important because, and Jeff and I talk a lot about it at these working group meetings we have, when we get into the challenges we're facing, the clinical teams in our court parts that do clinical assessments, they are severely understaffed and they are very backed up. And so there are some, I'm thinking actually of a client of Jeff's right now. The client, he is out in community, so that he kind of goes to the bottom of the list. The priority is always going to be incarcerated defendants to try to screen them as quickly as possible. So if you're out in community, you are looking, and unless it's a gun or domestic violence charge, those cases are also prioritized. You could be waiting months to have a clinical assessment for one of our treatment courts. Thankfully, he is in treatment. Jeff has gotten him into treatment, which is wonderful, but our influx of cases to these courts has not necessarily been matched by a lot of the resources that we need. And again, this is before expanding the scope of programming. So let me jump in here. These are, I know people love stats, so I told you we're really proud of them. We do these snapshots. So the last snapshot I have is in May. I'm sure very soon I'm going to get the like year end numbers, but almost 30% of felonies indicted in 2024 have been referred. And probably since that time, since May, probably even more of them would have been referred to Pathways for an in-depth assessment. So I told you every felony is getting looked at initially by our deputies, but for a lot of reasons, cases don't end up coming for this deeper review. Some of them are.
I'm sorry, it's hard to look at these numbers. Can you move that Zoom bar to the top? Thank you.
Okay.
And maybe you could.
Okay, so yeah, what are
Yeah,
you looking at
yes,
here? Okay,
yes.
this is the takeaway. We're gonna talk about each of these court parts, but the takeaway is this. We have over 1,000 participants in our felony, either pending and kind of pre-plea and pending waiting assessment in one of our felony problem-solving courts, or currently participating, over 1,000. I cannot tell you, and again, I'm sure Jeff or Danielle or other people who practice in this space will tell you, this is significant, it is dramatic, it is amazing. And it's a lot of work. So
What is the difference between how many people are considered and the percentage of people that are actually gonna go through?
Yeah.
So these people,
1,000,
these,
how many?
so most of these people here at the pre-plea, there are people who, like in our drug court, they're in the court part and they are waiting to be assessed. And so look, people can change their mind and decide they don't want to take the plea. As you can see, we have almost 700 who are post-plea. Those are people who are actively engaging in treatment, they are working to earn usually a dismissal or a misdemeanor off of a felony indictment. But most of this 330 will roll into the post plea. They will become active participants.
So chances are, if you are a offender and you have been chosen to be assessed, and then they're assessed, so say you're assessing 100 people. How many people actually end up with a plan, a pathway?
Well, okay, so I would say we have between probably 4,000 and 5,000 indictments in New York.
Okay,
There, in it like a year's time. There,
Really?
yeah. There's a lot of reasons that people either we don't think they're appropriate, and I wanna talk about
Okay,
some of that,
sorry.
you know, why.
Sorry.
But, or they don't think they're appropriate, or they get a better offer, or, you know what I'm saying? Like, there's different things, that can result in them not doing a treatment court disposition. But we're gonna get into it and then come back to me, you know, and I think my clicker stopped working. Can we go to the next slide?
That should work.
So Treatment Court Expansion Act, things that I think are wonderful about this legislation, this proposed legislation. I think Casey got into this a little bit. Right now, judicial diversion, that's our drug court law, Article 216. You have to have a substance use disorder in order to participate. The Manhattan DA's office has long felt that there's a lot of people with co-occurring mental health and substance use needs. And for a number of years, the clinicians working in that court part would say, look, he has a substance use disorder. He's charged with a non-violent felony, which most of I'm simplifying it ever so slightly, but essentially for our purposes today, non-violent felonies are eligible for that drug court, okay? He's charged with a non-violent felony. He has a substance use disorder, so he's eligible. But he has a serious mental illness. He's living with schizophrenia. And our clinicians are not equipped to work with that population. That's obviously a very unique and different need. And you need to be experienced and sophisticated, both in working with the population, but also in the provider landscape, right? So the DA's office said, you know, no more are we gonna have people who get turned away from, and then we would try to get them into our mental health court, right? But we realized that wasn't helpful. That wasn't helpful to the participant. It wasn't helpful to the community. And so the DA's office funded a mental health track in drug court, which basically put those expert clinicians in the court part so that no longer, if you had a co-occurring mental health issue, would you be turned away. However, and again, we still work with these folks. We just have to work with them in a different way, in a different court part. But let's say you're someone who has just a serious mental health issue. You have bipolar disorder, but you don't have a substance use disorder. You could not avail yourself of drug court, of judicial diversion, because you had to have a substance use disorder to participate. We would try to serve you in one of our other 2 felony problem-solving courts that I'll talk to you about. But certainly it makes sense to add, if they do nothing else to this legislation than say another qualifying diagnosis is serious mental illness, that's wonderful. It will codify mental health courts throughout New York State, which is wonderful. And let me just, since I mentioned New York State, I want to just remind everyone. And I was thinking about this during Casey's presentation because a lot of it focused on Rikers. We have to remember that this is statewide legislation. This is not New York City specific legislation. And I mention that because judges in different jurisdictions have very different philosophies. I think like, it seems like reading between the lines of the legislation, the drafters think that judges, you know, will automatically divert more people than are currently being diverted. You know, it's something to think about. I don't know that upstate judges are gonna necessarily do more than DAs do, you know, in terms of making offers. But that aside, the treatment landscape in New York State, we are lucky. We are in a treatment-rich environment in Manhattan, and I can tell you there are still major gaps in the provider landscape. This is a state law. Up by Niagara Falls, you know, this will be the law of the land, so to speak. And if you know, and I want to get into some of the concerns I have in a minute about the treatment landscape and what this will do to it, but we need to really appreciate that this is not just New York City, you know. So codify mental health, the SMI, so serious mental illness, put it in, it's a great idea. Expanding charge eligibility, but I would say in a reasonable and common sense way. I've spoken to Jeff and Casey and some of the folks who drafted or helped draft the legislation, and I gave them some areas that, you know, personally, and I have to say, this is not even the position of the DA's office. This is my position as a practitioner who's worked in these courts for 10 years. There are certain very obvious charges that we could add to expand eligibility. Additional funding for certified peers. We have certified peers are so critical to the treatment court process, and they are, I wouldn't want to say absent, because I think we maybe have like 2 or 4, 2 in each of 2 of our felony court parts. But when you're talking about serving, you saw hundreds and hundreds of participants. Certified peers are folks who often have lived experience. Either they've and actually our neighborhood navigators, going back to that for just a minute, these are folks with lived experience. They have either been unhoused, they have lived with serious mental illness, they have lived with substance use disorder. You know, in our treatment courts, peers really should have experience in the criminal justice system. That's great. And they can engage with the participants in a different way, right? We're going to talk a little bit about everyone has very different roles in treatment courts, and having a peer that can escort you to your program and talk to you about, you know, some of the challenges you're probably going to face when you go to that program and how she dealt with it when she was in your shoes. These are wonderful, wonderful resources, and they mention it in the legislation, and I think it's excellent. The legislation mentions some data collection. I would go, I think, and Jeff, you can please tell me if I'm wrong. I think some of the data collection that was written into the legislation was around like how many people apply to the courts, how many people ultimately are admitted to the courts. I would go much further, because the success of this legislation, the success of the court, and the success of the community that we live in is based largely on the quality of the community-based programs that we work with. Also, and we're going to talk about it, very long wait lists at a lot of the programs.
Yeah.
Huge, huge gaps in services. And this is, again, in Manhattan, in the most treatment-rich environment. So I would love to see the data collection go further, because only when we can show, you know, this is what's happening in the treatment landscape, do I really think that maybe, although we've been kind of ringing this alarm for a long time and I'm still not seeing the investment in the treatment landscape. This is, you know, I'm a little bit all over the place, but I have to tell you on that point. This afternoon, I had a call with someone who works with individuals with intellectual and developmental disabilities. And we were talking about how hard it is to get many of our participants who are living with those disabilities into OPWDD housing. OPW is the Office for People with Developmental Disabilities. And one of the things that was shared with me is that, I guess during COVID, many facilities and homes were closed. And largely, I
Like
think
group-
because of
like
staffing.
group.
Yes, group homes, exactly. And I think, and the person who was speaking to me was touching on, and not just the home being closed, but also the staffing issues that have kind of persisted. They've never opened. Like, these are the gaps that we're talking about, that we don't need to wait for this legislation. We have someone, you know, who has power on this call, right? Someone from Senator Ramos's office. Please, like, I would love to have a meeting to talk about some of the gaps that we're seeing today, and implore you to try to do more to you know, get the help now, to build the structure now. But anyway, data collection will help, so support it 100%. Okay, I want to talk a little bit about treatment courts. This is a little bit what we were talking about before. Treatment courts are not, and again, there are different, and we're going to talk about this, there are different types of treatment courts. And there is a proportionality to the work that we do. By that, I mean, I talked about desk appearance tickets. Those are misdemeanors. You're eligible for a DAT, which tells us that it's probably not like a sex crime misdemeanor. It's maybe a pettit larceny or drug possession misdemeanor. We can't put that person in treatment or require them to do treatment for even, you know, a month. It is not proportional. to the, crime charge, to the, I don't know, leverage is the only word that really comes to mind that we have to work with, right? And so a lot of the interventions are proportional, but treatment courts, as we're going to talk about them tonight, are not mere voluntary connections to services. It is not saying, and again, I cannot emphasize this point enough. Most of the people that we work with, especially in our felony problem solving courts, but even in our misdemeanor courts, it is not that they have never just been connected to treatment before. Again, many of them have had family that have tried desperately, have been with practitioners via the hospital, or, I just met with someone the other day who said, well, I went to therapy twice and, it wasn't for me. Like, there have been these connections, and for some reason, and sometimes this is part of the disease, right?
Yeah,
Sometimes
for
not,
sure.
not acknowledging you have the illness, not understanding that you need
Or you don't like
medication.
the way the meds make you feel.
Absolutely, absolutely. But it's not just like, we're gonna make a treatment referral and everything's gonna be better. Not at all. Not at all. Now that happens for a lot of people, right? A lot of people kind of never end up in this system because thankfully, they have the support or whatever it is to voluntarily engage. Oh, Jeff has his hand up.
Thank you, Tony. I just wanted to clarify one of the things that you're saying, and then I just might give a response, but I want to make sure I understand what you're saying. Because my experience, as someone who has been advocating for treatment-based dispositions now for 28 years, which is how long I've been a public defender, is that a reason given why our clients should not be given a treatment-based disposition is because they've had a chance to be in treatment in the past and they didn't do it. So if I understand you correctly, because you brought up before the shelter system, I think you brought up the hospital. I think that it kind of, if that's what you're saying, I think we need to give context to that, because people who are cycling in and out of the hospital are oftentimes they're homeless. So yes, they are given an appointment. How are they going to get to that appointment? They're not, because they're going back to the streets and then they're going back to use drugs. So I don't really count that as having had an opportunity, because the failed systems in their lives, when it comes to healthcare, when it comes to housing, when it comes to, you name it, that led that individual into that situation. And then they end up in the hospital or they end up in the shelter system and they're surrounded by people who are using drugs, and they're in a very unsafe environment. I don't really count that as a lack of opportunity. Also, treatment is not, there's a lot of stigma with treatment. There's a lot of stigma with treatment for certain, for people of color, for people of different races and ethnicities. I have a client now, who's, success in drug court. He's doing actually very, very well. And he's a Korean American. He's been using drugs for years and he never told his family about it. And for the first 5 months of this case, he kept it all from his family. Thankfully, he was able to open up to them and they're, supporting him now. So if I understand you correctly, because I've been told that many, many times. They've had a chance or they, and didn't work out. So how can we know that it's going to work out now? I don't personally agree with that, if that's what you're saying. You can clarify what you're saying.
Sure. So I think the word chance is maybe what we're, first of all, again, Jeff, tell me if you disagree, but when we just looked at the numbers of the 1,000 people in the felony problem solving court space, almost all of them have been at some point offered voluntary services before. And ultimately, they're in felony problem solving courts. So the idea that because someone didn't follow up, on a discharge from a hospital and we don't consent to them going into treatment, that is not true. And I don't actually think that's been your experience. Certainly that's not anything that I would ever, approve of. Are there times where someone, and we can use this example actually, because this does come up with more frequency. someone is in Rikers Island and their attorney, the bail is set, it's a certain charge, so usually it's a violent crime if bail is set, applies to have the person released on an alternative to detention, which basically is usually the defense will say to the judge, and they'll ask for us to consent, I have a plan set up for this person. We're gonna have an escort take them to a residential treatment program where they're gonna get the help that they need for their mental health and substance use issues. And they're gonna be able to have their case pending when they're out in that setting versus in Rikers Island. The judge allows the person to be released to treatment, and the individual, when and this, Jeff, I mean, again, I think we just need to be really honest about what is happening so that we don't make false promises and then things slide backwards and there's a backlash. Well, hold on one second. So, I mean, Jeff, this is the reality. I don't want to say it happens frequently, but I wouldn't say it's infrequent that someone is released to programming and either they leave the escort on the way or they go to the treatment program and they stay for a week and they leave. Even in those situations, and you know this, Jeff, in our problem-solving courts, there are many times where the people will convince the judge to give another shot because we know treatment is really hard, and especially the beginning of treatment is really hard. But on a very serious violent felony, when someone is offered treatment voluntarily, as part of an alternative to detention, they leave treatment, and especially when they come back involuntarily, which usually means there's been a new arrest, it puts us in a very challenging position to have to go before a judge and say, we continue to support a treatment disposition in this case. Relatedly, and I think this is the other instance when sometimes you see us having concerns, Jeff, if someone, and this is true of some people living with serious mental illness, if they were in community and they were under the care of an ACT team, which is really the highest level of outpatient care that we have available. These are teams with it's an interdisciplinary team with a psychiatrist or a nurse, psych, usually a peer, social worker. A lot of times they are trying to convince their clients to get on injectable mental health medications. If you have that level of care and you still committed a violent felony, I think sometimes we do ask the defense attorney, what's going to be different this time? Like, this person had, these services and still committed this crime. I do think, to Jeff's point, that, well, Jeff, let me let you respond and then.
I mean, I first of all, second chances, I understand that the treatment courts give second chances, but I would say generally speaking, because I've had clients who were released as part of an alternative to detention. And you know what, let's talk about the client that you mentioned earlier. That's my client, the one that can't get into be assessed right now because they're so backed up. That client actually completed the 12 months of a residential treatment program, and I've been advocating for treatment for him for the past 3 years. And I truly appreciate your office's finally changing its position and being willing to refer him to a treatment court over the victim's objection. And I think that's wonderful, and I really appreciate that. But this particular client has been in treatment for about over 2 years now, 2.5 years, including residential treatment without once getting rearrested. So I think that when somebody like that client relapsed early on in their programming, that was seen as an indication that they can't, because there's drugs in the programs, because people are bringing K2 in the programs, people are bringing crack, cocaine, they're bringing marijuana, they're bringing it all in the programs. And although we are a treatment-rich city, which is true, this is not where the Hollywood stars go, these programs. And people are bringing drugs into the programs. And if a client of mine is subjected to that, then that's, and this happens a lot, actually. It happens a lot. That's a reason of concern for you. It's a reason for concern that maybe you're not going to actually feel that this person could be safe in the community.
But Jeff, I'm so sorry.
And I also want to say, Tony,
Not true. That
that
was
pre-
not the problem with him. And you brought it
Okay,
up, so,
okay.
okay, you brought it up, so
You guys
but we really, I think we need to be really transparent. And here is the real reason that Jeff's client, it took us a long time to get to yes. We have a victim who has severe injuries, who wants Jeff's client to go to prison. Jeff's client was released to treatment, and you brought it up, so I'm going to speak about him. He was released to treatment. He was discharged from multiple programs, once for strangling. This is my recollection, that he strangled. He had a physical altercation with someone. It was never about him relapsing. But when I have to sit before a victim and I have to say that we are going to do something different than what you want, and you know what? We take what victims want very seriously, but I also tell my staff all the time, we have to have courage, and we do not work for victims.
But I have to say, I feel like this is not the place to adjudicate.
Yeah, I agree. I
use that
agree.
word.
But I do want to say this, that I think that success in treatment at the end of the day comes down to readiness. It comes down to readiness. I have clients who are 65 years old and they're like, I'm ready. All right. I have a lot of clients who are younger who aren't very mature and they say they're ready, but they're not ready because they don't have life experience. And by the way, this is one of the reasons why I think the pre-plea model is very important, because when you enter into an agreement with the court and you're signing your life away and you're going to have 3 years jail hanging over your head and you're 25 years old and it's your first time ever in treatment, I mean, it's very possible there are going to be problems along the way. Obviously, if that person gets rearrested for something serious, I understand, then it's not going to work out for them. And that does happen. But you know what? That's going to happen whether a judge is deciding it or whether your office is deciding it. It's going to happen. Your office screens people that you look at voluminous records that we're required to give you, are thousands of pages of hospital records, where you're combing these records for public safety concerns. These are records of our clients in having psychiatric hospitalization. They're there because 2 psychiatrists determined that they're a safety risk. They're there for a reason, and you're going through all these records trying to find examples of, did they ever have a knife? Did they ever set a fire? Did they ever do something sexually inappropriate? And you know what? Sometimes when you don't find that stuff, you still send the person to treatment court and then they still mess up. So my point is that I would rather have a judge make this decision in collaboration with a clinical evaluation where all the parties, the defense, the prosecution, the clinician can weigh in, and then the judge can make an informed decision, as opposed to a prosecutor and your deputies who are combing through these records. There's no clinical evaluation. They're not therapists. They're not clinicians. They're prosecutors, respectfully. And then after that, after you've gone through all these records and met our clients in person, which is very, very difficult for our clients, because that's a requirement for our clients to be diverted into a treatment court, to meet.
Look, Casey had her full time, and I have a lot I want to get through. And then I promise I'm going to touch on this. But Jeff, again, we have to be honest. Over half of the people who are going to problem-solving courts do not meet with us. They can get drug court without our consent. The cases where we meet and we look at records are cases that are charged as violent felonies. The defendants present grave public safety risks. We as prosecutors have an obligation to public safety. The clinician is not going to report on whether or not someone is a public safety risk. That is not what they do. And so it is our sworn duty as prosecutors to do it.
Required to?
No, the
Wait,
clinicians.
I'm sorry, if you're a clinician and you are, like, if you go to a psychiatrist and you present in a way that you are apparently a risk to yourself or your others, like, isn't that what you're talking about?
That is the highest, and Jeff will I think he will agree on this. Harm to self or others is an extraordinarily high standard. We have countless people who are charged with violent felonies in our courtrooms who would not be determined by a clinician to be that level, even though they've committed violent felonies. That is a very specific standard in psychiatric care. It authorizes involuntary commitment.
Right.
In our experience, just for a few days, and then people are right back out on the street. But that is our clinicians overwhelmingly in our treatment courts. And this actually, this gets into like kind of treatment courts 101, which I do want to center ourselves on for just a minute. Everyone in a treatment court has a unique role. The judge is the ultimate arbiter of incentives, responses. If the person is struggling,
Right.
do they make them come to court more frequently? What do they make them write an essay, a reflective essay, these sorts of things. But of course, the judge takes input from all parties, including the provider in the community that is serving the person. Then every treatment court is supposed to have an independent clinical team. It doesn't work for the defense. It doesn't work for the prosecutor. Essentially, it's an arm of the court. And they are to assess someone's needs and recommend a treatment plan. So this person has a substance use disorder. We think they need intensive outpatient treatment. This person has a serious mental health issue and a substance use disorder. We think they need a residential care. So that is their role. It is extremely rare that a clinician in any of our problem-solving courts will say, this person is too dangerous to engage in treatment, or this person is unlikely to be successful in treatment. And Jeff, tell me if you disagree, but that is not the role of the clinicians in our felony problem-solving courts.
I would say this, Tony, with all respect, and you and I do share a lot in common, and you are a personal friend. We have the same birthday. We were both teachers, and we were both
Let's say what it
teachers.
is. Someone might steal our identity, Jeff.
Teach for America. We were both teachers.
Yes.
I will say that Manhattan is the only borough in New York City, the only borough that requires the defense attorney to provide all of these records over to them for non-drug court cases. It's the only borough that requires a proffer session for most non-drug court cases. And guess what? The Bronx Mental Health Court doing very, very well. And Judge Demick in Brooklyn doing very, very well. And their graduation rate is very high. And you know what? The prosecutors in the Brooklyn DA's office trust Judge Demick. They trust him, and they give the clinicians an opportunity to put together their evaluation. And you know what? At the end of the day, Tony, the Manhattan DA's office, you could say you could stand up and shout and scream and say, we're against this, and here's all the reasons why, and blah, blah, blah. You can do all that. But I do want to say one other thing that's really, really important. Your boss is Alvin Bragg. Your boss is Alvin Bragg. Before Alvin Bragg, it was Cy Vance. What if Alvin Bragg doesn't last past this term? And when Cy Vance was the DA, very few people were being diverted into mental health courts. Very few people were getting treatment as an alternative to incarceration. It was completely horrible. And my point is, are we just going to say, oh, now we're going to go back to the old way it is? Should who is the DA determine equal access to equitable justice? I don't think so.
Well, I have to say this about DAs, and there's so much I could say right now, Jeff, but I think we're going off.
Can I ask before you go there,
Yeah.
what provision of the Treatment Court Expansion Act are we referring to right now?
Well, so the Treatment Court Expansion Act wants to take right now, again, you can get on a non-violent felony, you can get treatment without the people. But they want to include, and we're going to talk about some of the charges, attempted murder, rape 2, kidnapping, arson, and be able to do it without any offer of the people. Usually on those violent cases, the way people get treatment is because the DA's office says, we're going to make you an offer. If you're successful, we'll ask the court to dismiss the indictment. We'll let you replead to a misdemeanor. Now there's a lot of different pieces here, and there's so much I want to address, but in terms of the DA and the role of the DA, I have to say this. In many courtrooms, the DA is the only elected party present. They are the voice of the people. In New York City, many judges are appointed, they are not elected. Obviously, defense attorneys, they have Jeff and his colleagues, and I have so much respect for the profession, but he has a sworn oath to be a zealous advocate for his client. He is only interested in his client. If his client wants treatment, even if Jeff thinks he's not going to be successful, even if Jeff thinks he might hurt someone, Jeff has to advocate for treatment. If Jeff thinks the client should go to treatment, but the client says, I just want to plead out my case with the best offer that I can, he, as a defense attorney, has to do what the client is asking. That is his role. In terms of, and I do, because this is so important to the conversation about the specifics of this legislation. All Rise is the National Association of Treatment Court Professionals. They used to be called the National Association of Treatment Court Professionals. Now they're called All Rise. All Rise puts out best practices, national practice standards. These are based on decades of research in problem-solving courts. I encourage everyone to visit the website. It's very detailed. There's a lot of trainings and such. One of my concerns about this bill, and we're going to get there, are that many of the provisions are actually not aligned with best practices in treatment courts. They are trying to adopt maybe best clinical practices, but again, best clinical practices are different than best practices in treatment courts, and I want to talk about that. I also want to, and I'm just not going to be able to get into all of this tonight. I want to keep it moving, but it's very important that everyone understand the individuals we're talking about, the participants in our problem-solving courts, are very complex. As Jeff mentions, many of them have long histories of non-compliance with medication, where they went off the medication. And Jeff mentioned we do meet with many people who are charged with violent crimes. And one of the questions we often ask is, I know you've been asked to take medication before and you didn't. Can you explain to us, what's different this time?
Can you pause 1 second? Rocio, wants to speak.
Yeah, sorry to interrupt your presentation. I just had a quick question on the All Rise portion of your slide. Who essentially decides what these best practices are? Is it like a board of folks, diverse board of folks that decide what the best practices are, and then they go from there? Like, how is that determined? And kind of just like a point based on your exchange with Jeffrey, I'm not a lawyer. I'm not in these courtrooms. I'm not the one practicing law, on either side. So this is more so from like a personal standpoint and what I've seen. I was born and raised in the Bronx, and I've met a lot of people, who've gone through this process. And treatment, it's not linear. So I think we really need to approach this kind of issue, and not necessarily the bill, but the issue at hand that's affecting so many New Yorkers, as more so somebody just needs to have somebody in their corner to give them a chance, to let them know that they're not going to give up. Yes, people will make mistakes, people might fall back. It's a disease. People they battle with this for so long. So I think I understand what you're saying, but I think it's not so linear and it's not as clear cut as you might present it to be. But that's just my opinion and what I've seen in my neighborhood, as well as like, working in this position with Senator Ramos and kind of her experiences. And that's the whole reason why she, is collaborating with so many folks on this bill. But that's just a comment, and I will not sure if you have an answer for the All Rise.
I can't agree more with what you just said, and I am sorry if I have suggested to anyone that we expect perfection from the jump. I would love for you to come to the felony ATI part where Jeff and I practice regularly. He will tell you, maybe he can tell you right now, we give countless opportunities in treatment court, countless. Many times, even when the judge, and not necessarily in that court parts, but across the board, if sometimes judges want to sentence defendants and we ask for them to give them another chance. One of the reasons that some of our folks are with us for so long is because the struggle is real. And honestly, in that court part, in felony ATI, unless you're getting rearrested, you're almost certainly going to be allowed to continue. We really, really want to continue to work with people. We understand it's not linear. And if I said anything to suggest that we think it is, I apologize, because again, we are specifically trained in the nature of addiction and we understand it is very complex.
I agree. I mean, I want to just say that's correct. That is, first I want to say, there's a lot of very positive things about your unit. And I just want to be clear about that. You are diverting way more people than Alvin Bragg's predecessor. And I give you full credit for that. I give you full credit.
Don't give me credit.
I
Don't give me
do give, you know what, I give Alvin Bragg credit for that. But there are still, you're talking about all the chances you're giving people. I mean, there are so many people that are never given that chance because they're either not invited to meet with your office because of something you saw in their past or their charge, or maybe the victim's position. It could be a whole range of reasons. And then they go to prison. And then they go to prison and they're exposed to drugs. And when they're in prison, they're exposed to gangs and they're exposed to violence. And when they get out of prison, they're on the street. And then they're back in the hospital having another psychiatric hospitalization. Before you know it, they're rearrested and they're back at Rikers again. And we're going through this entire process again. Those are the people that we talked about earlier. But I do give you credit for all the people that are being diverted. That is nothing like the rest of the state. Nothing like the rest of the state. This is a New York State bill. And earlier you talked about how you don't know if the judges are going to want to do this. The problem is the prosecutors aren't doing it because the prosecutors throughout New York State are the gatekeepers. They make the decision whether you win the lottery or you don't win the lottery. And it literally is like winning the lottery if you're allowed to be diverted into a treatment court. That's what it feels like. And every other part of New York State that's not
You don't need, when you're charged with most felonies, you do not need the people's consent to go to judicial diversion.
I'm not talking about, but Tony,
violent.
that's drug court. Drug court is so limited. We're not talking about drug court. You know that. We're not talking
Honestly,
about drug court.
Jeff, again, and I want to talk about why I think DAs have the authority they have to consent or not consent. But one thing that, and this is sad, and this is something we see with some degree of regularity. There are people who are very mentally ill. They do not have insight into their mental health issues. They do not think that they need to be in treatment, and they affirmatively refuse to take medications. When you are charged with committing a violent crime, and that is where you are at, we do not want you to go to Rikers. That really is not what I think any prosecutor in any office wants. But we also need to be responsible and releasing you to a treatment program when there is zero hope that you are going to engage in that treatment program, and that we know when you are not engaged in treatment and you are not receiving the care you need, you present a very grave risk to public safety. I wish there was a third lane.
So would you not defer to a judge then? I understand that the defense counsel's obligation is to the defendant. And I understand in theory that a prosecutor's job is to bring justice. That's not always how it works out, but there's also pressures on prosecutors. I think what Jeff wants is simply, and what the Treatment Court Expansion Act wants, is to transfer some of this responsibility to the court from the prosecutor. Is that right, Jeff?
May I just give an example? I think this is a very,
I just want to make sure I got, Jeff, again, I, with all due respect, Casey had, her full time. I have a lot more that I want to get through. I want to answer your question, but can we also move to the next slide? Because I do want to keep things moving. One of the things that our ability to consent gives us is the authority to ask the defense to provide us with certain information. When that is taken away, and we know we don't have to guess what that looks like when it's taken away, because in drug court as it is right now, it's taken away. The defense does not provide any information similar to what we receive now when we have to consent. And so it is very hard when we have a clinician that really is not weighing on public safety, and the risk presented to public safety. We don't know whether or not, this is just a slide real quick. This is more about treatment court 101, incentives, sanctions, adjustments. This is all behavior change. This is how treatment courts inspire behavior change. But if we didn't have the authority to take a position and to consent and make the offer or not, we would have to make decisions with much, much less information. the records that Jeff supplies that shows his client is not taking medication or is refusing to engage in treatment, we will not have access to those records if we do not have the power to offer or not offer. I spoke to a practitioner.
Can we let Jeff respond?
Oh, go
just
ahead.
To that?
Mhm. Right, Jeff? I mean, in drug court. you don't-
but okay. Your office is so used to being in control of the process. That's the issue. You're in control of the process and you don't want to lose that control. Your office has more control of the process than any other district attorney's office in New York City. So yes, you're right. You might not get the records. You might not get the records, but you know who's going to get the records? The clinicians who are writing the evaluation. They're going to get the records and they're going to consolidate all of the records and all of the information that they get into a report that you are going to read, that the defense lawyer is going to read, the judge is going to read, and then the judge is going to do a public safety analysis to decide to make a decision. And they're going to hear from you, they're going to hear from me, and they're going to make a decision. And you know what? You don't always get it right, Tony. You don't always get it right. I have a client who was charged with a sex offense, a violent sex offense. Your office, I advocated and advocated, and I said, please let him be diverted to mental health court. It was the first break of schizophrenia. And you said no. Thankfully, I was able to back his case into the Manhattan ATI court over your office's objection. Thankfully, because he would be pleading to the charge, giving himself permanent sex offender registration act for the rest of his life and a violent felony. He was so good in treatment. He was so successful. He was such a star that after he completed residential treatment, after he transitioned into mental health supportive housing, and Judge Biden, she was the judge that took him over your objection, a violent sex charge. After that happened, your office, to its credit, with the victim's consent, reduced it to a misdemeanor because you credited how well he did. The judge got it right, and you guys didn't get it right. And all I'm trying to say is, it's not I think that your office, respectfully, is just so used to having the control. And if there is a treatment court expansion act, what's going to
But
happen
Jeff,
to
the
you?
clinicians do not do a public safety analysis. That is not
They do
fair.
violence risk assessments. That's not true.
So
They do violence risk assessment.
Let me ask you a question. So will you write into this legislation, or will you suggest that on every case there's a violence risk assessment? Because that is absolutely not done. And in fact, public defenders like yourself continually oppose. And in terms of getting it wrong and right, we are human beings. It is an imperfect world. We do the best we can with the information that we have. You, Jeff, I hate to bring it up, but since you brought up this case, you have gotten it wrong, sir. Many of your participants have gone on to commit very serious crimes. The individuals you advocated to go to the treatment programs. It's not fair to suggest because someone does better than we fear they might, or worse than they fear. We are doing the best we can with the information we have. And what I need everyone to understand is that the clinicians in these court parts are not doing public safety analysis. They are not. And as Jeff knows well, often it is because we review significant amounts of information and yes, sometimes meet with the individual and we ask them, what's going to be different this time? You know, I see you're not taking your mental health medication. You have to understand that's part of this treatment program. Are you willing to do it if you enter the treatment program? It is that information that allows us to advocate with the judges. And you know we do, Jeff. We advocate for the judges to take very challenging cases. Very challenging cases.
In every case that gets referred to mental health court, Manhattan Mental Health Court, that has what, 39 participants compared to the hundreds of participants in Brooklyn and in the Bronx. In every single case there, the judge orders a violence risk assessment if it's a violent case.
And those
single
are
case.
the only cases.
And you know what? Those are not going to go away. Whether or not there's language in the statute that calls for a violence risk assessment, the judges in New York City for a violent offense are going to ask for it. And there's
That's
nothing.
not true.
And there's nothing in
New
this.
York County Defenders refuses, as I understand it, to even cooperate. Look, I
Okay,
just want to
so-
get back on
Wait,
this.
let's pause here for a second. I'd like to see if any of the committee members, first of all, have questions for what you presented so far. And then I'd like to just get to the specific disagreement,
Okay.
areas of disagreement. So first, do you?
Well, I mean, I'm just now, I feel like I'm getting like confused with the banter here. You don't see all cases that go, you're not, are you looking at every case that's getting sent to treatment court?
On
The
felonies,
DA,
on felonies.
so on felonies, not misdemeanors.
Well,
So
Many
are you the first line? You're the first line, the DA's
We are-
I'm trying to understand how
yeah,
this is
so,
working.
well,
So
the
confusing
judge
now.
is usually the first person
Okay.
that sees, so the DA's office writes up a complaint with the
Right,
allegations,
okay.
and then someone usually goes before the judge. And then, again, we have this proactive process because we really wanted to increase referrals. We wanted to try to catch as many appropriate candidates as possible, and we wanted to do it as early as we could in the process. And so this is why we have these deputies that sit and they review every felony that happens in
Every felony
every felony in Manhattan within 48 hours of the arrest.
goes through the DA.
Goes through, yes, goes through a supervisor in our division. And one thing, you know, Casey, when she presented, she suggested that because we have a lot of different treatment courts, that I think she called it a labyrinth, and she treated like this, like it's a bad thing. And I really want to emphasize that actually multiple treatment courts is a great thing. It is best practice, and it is because of this. You do not want someone who has maybe an older gentleman with a very long criminal history and a serious substance use disorder, commingling, so to speak, with someone who is much lower needs and maybe, you know, is experiencing kind of their first psychiatric issue, but doesn't even have a substance use disorder. We have so many court parts, and again, we've worked with a lot of partners to build this out, but this is a good thing because it allows us, for example, our emerging adult part. Young people are very unique. They have unique brains, they have unique needs, and so we can specialize, and we want them to be in a part with others their own age.
Okay, this doesn't affect any part of the TCEA?
Well, it does in that Casey this was, you know, kind of what the messaging that I heard from her. She was suggesting that having all of these court parts is a bad thing. And this legislation will allow just one court part for all of these folks. First of all, one court part could not even sustain the amount of cases we have right now. But it's also not best practice. It's not best practice to suggest that everyone should be in the same court part. That's very bad.
First of all, just so everyone knows, when you say court part, you mean one courtroom.
Courtroom, court model, you know, for example,
Court type.
mental health court, emerging adult, you know, we have treatment courts for sex trafficking, you know,
Okay, but
victims.
let's just focus on the TCEA if I can. The disagreement you're having now, as I understand it, is whether is the degree of authority that the prosecutor has as opposed to the discretion that the judge has. Is that right?
Well, so let me turn to my concerns, but I do hope that you allow me to go back and.
I'm sorry, we're like 90 minutes in, and you look like you're about a third of the way through the presentation, and like, yeah.
All right, so let's talk about concerns. One concern I have is that the act as proposed is conflating clinical models of care with best practices in a treatment court. Role of the judge. Let's talk about role of the judge. The best practice in problem-solving courts is that the presiding judge hears from clinicians and legal parties and makes final decisions regarding adjustments to treatment plans. The proposed legislation says that a treatment provider may modify a treatment plan with the consent of the participant. That's the consent of the defendant. It does not require you know, the parties to come together and for the judge to make a determination. Here is the problem with that. Clinicians who are servicing folks in community, they have an obligation to that patient. If that patient says, you know, I want to continue to use heroin, but I want you to help me use it in a more safe way with clean needles, then that is the clinician's goal. If the patient, and we see this sometimes in our treatment courts, if the patient says, I don't want to go on mental health medication, or I want to go off my mental health medication, the clinician will work with them to go off it.
Okay, so you would,
The court, the best practice, this is not Tony saying this, this is not the Manhattan DA's.
The problem with the term best practice is we don't really know.
Well, we
what
do
established.
because we have an entire association that is committed, and it's made up of practitioners, judges, prosecutors, defense attorneys,
What is it you say is the best practice then?
that the judge is the ultimate one who decides. I'll give you just one last example that will illustrate this.
No, don't even. But just if you would prefer that the judge has a choice about approving a change in treatment.
Absolutely.
plan.
If someone is in residential treatment
Jeff?
and the
how do you-
clinician,
How do you feel about that?
I don't agree with what you're saying about best practices, because actually the standard practice is for a treatment court judge, including a drug court judge and a mental health court judge and a veterans court judge, to have the presiding judge make the final decision about whether to accept a participant with nuances. They have to satisfy legal eligibility.
who makes the decision about clinical plans? That's what we're talking about.
No,
Clinical
everybody
If someone's
has
in
their,
residential treatment, hold on, if someone's in residential treatment, and that's the place that's been designated for them, and they say, you know what, I wanna go to outpatient, and I wanna go to outpatient tomorrow, I'm done with residential treatment. You think that it's best practice for the clinician, without coming back to the judge and the parties, that the clinician is gonna do what the client says. But that is not best
that's
practice in
not
a
true.
trauma.
Okay, everybody, the way the best practice standards work in the United States in every single treatment court is that everybody's got their role. You're correct about that.
And the
The
judge
has their role, the clinicians have their role, the treatment providers have their role, the prosecutors have their role. The judge is like the umpire. They're the ones making the decisions, and they're being given recommendations. The best practice is for a clinician and not the judge to make treatment court decisions, but to make treatment-based decisions. You know what? I practiced in front of so many judges in Manhattan going back for years, where they're telling my client who just had back surgery that they're not allowed to take a pain medication. You know how dangerous that is? Because then they can go out and overdose. Clinicians who are familiar with the person's mental health, drug history, all of it should be making the recommendations. Of course, the judge is going to oversee that.
Of course, but the judge should be the ultimate decision maker. And the way this legislation is written,
they are.
it says,
Okay, wait a minute, I'm sorry. I think we understand that concern.
okay, so that's my concern. The legislation allows the treatment provider to make decisions about changes to clinical plans and not the judge. Toxicology testing. Best practices and I'm quoting here from All Rise. Forensic drug and alcohol test is conducted frequently enough to ensure that unauthorized substance use is detected quickly and reliably. Urine testing, the most common methodology used in treatment courts and probation programs, is administered at least twice per week until participants have achieved early remission and their substance use disorder and are reliably engaged in recovery management activities preparing for graduation. Again, these are not folks who are coming to treatment voluntarily. They are usually engaged in treatment because they are choosing it over a less flattering alternative, which is often jail. So usually, and this is the best practice, if you have a substance use disorder and your substance use disorder drove you to commit the crime, you are obligated to submit to toxicology testing. If you test positive, that's okay. We're gonna work with you. It might mean you need a higher level of care. It might mean you need a little more support, but toxicology testing, especially early in the mandate, is best practice.
You're gonna work with them.
The legislation says that drug screens shall comport with OASIS guidance on toxicology testing. OASIS is the clinical licensing agency for substance use programs. Their guidance does not comport with what I just told you about best practices in a treatment court. I think that, again, my concerns around this legislation, and I have a few more that I really want to get into, I think that we really need to think about best practices in treatment courts, not best practices when people are going to treatment voluntarily.
Okay, let's hear Jeff respond to that, please.
You know, I agree that you know, the best practice actually is to start at the least restrictive form of treatment if possible. So, outpatient, and then if the person is using substances repeatedly, then they could move on to an inpatient or a detox, and then an inpatient if it continues, then a residential treatment program. My experience, however, is that judges, actually prosecutors, say residential is all we want. We want residential because hold on, we're concerned about public safety. That happens. And second of all, New York City is really progressive when it comes to relapsing. And your office is very progressive when it comes to relapsing. And the judges throughout the city are. But I'll tell you what happens in the rest of the state. You smoke weed and you're not supposed to. You drink alcohol and you're not supposed to. You use cocaine and you're not supposed to. You're not getting a slap on the wrist and having to write an essay. You're being put in jail for the weekend. That is New York State. That is not New York City, but that is New York State. And the Treatment Court Expansion Act is going to primarily affect New York State.
Jeff, you agree, though, it sounds like the toxicology testing is an important tool in treatment courts. And so it
Absolutely.
shouldn't be OASIS guidance. It should be what the best, because right now, that is not what is written into this proposal. It references OASIS and best practices in treatment courts. Those don't align because they're two different, they're interested, or, they have like a, it's like a Venn.
Oh, it's a for-profit?
No, it's an agency that licenses drug treatment programs. And so again, it's like a Venn diagram, and we sit in the middle. There's the clinical, there's the legal, and problem-solving courts are in the middle. And
So Jeff, Tony thinks you agree with her on this?
I believe that a toxicology should be used for the purpose of informing treatment. It should not be used as a sanction. It should be used for the purpose of informing treatment. So for example, I work with ACT teams, an assertive community treatment team. This is one of the highest level of mental health services somebody could receive in the community. And Tony referenced them earlier. Their position is that they're not going to be toxing somebody every 3 days. I mean, and if somebody tests positive, they're going to use that information to inform the next, what changes need to be made, if there needs to be a referral into some other form of treatment. I believe it should be used as not punitively, but as a way to inform treatment.
So the two of you seem to be disagreeing on when the judge should make the final decision. In one case, you're saying that it should, the prosecutor should get a say. In the other case, when it's involving OASIS, you're saying it should not be the judge, it should be the clinician, right?
No, I think with OASIS, again, this is specifically about so a lot is written into this proposal that is not in the existing law. The existing law, as far as I know, doesn't, mention toxicology, no toxicology. But the new proposal specifically references OASIS standards. My issue is, and I think what Jeff is acknowledging is toxicology testing is a really important tool in drug courts. The way the legislation is written, by kind of deferring to OASIS standards, is not in line with this 2 times a week standard, especially early in treatment in drug courts. So I'm concerned that is a very important tool. It helps us know what's happening. I also think we can all appreciate that a lot of our participants will not be forthright if they are struggling with relapses. And things can go off the rail very quickly, so we need to know. I want to highlight what is one of my biggest concerns, and Judge Wilson.
I want to give Jeff a chance to.
We asked Tony to come in and present. We'd like to let her present on the concerns of our office. If we can let her present, and then maybe Jeff can respond, but can we let Tony make the points that
We
were asked to present on?
can, but if you can make them sort of neat and fairly expeditiously, that would be good.
Okay, I'm trying.
We
It's
can tell you very
complicated.
fast.
Okay.
It is complicated. We are used to dealing with complicated issues. And we also appreciate brevity.
Understood. Right now, and I didn't get a chance to get into it on a previous slide, but we talked a little bit about how backed up the clinical arms are in our courts, doing assessments and moving people into treatment, right? Currently, as the law is written, a judge in judicial diversion in drug court, again, don't need our consent, can look at someone charged with a nonviolent felony. And if there is something, particularly concerning about the person and they don't think treatment is appropriate, they don't have to order an assessment. They can just basically say, I'm not going to divert this person, no matter what a clinical assessment showed me, that's not going to change my mind about this. So I'm not going to order the assessment. The proposed legislation expands the eligibility criteria in terms of charge. Let me tell you just a few of the charges that become eligible: attempted murder, aggravated manslaughter, gang assault in the first degree, strangulation in the first degree, kidnapping, arson, coercive conduct against a child, persistent sex abuse, rape in the second degree. I think these are cases that we could likely conclude that a lot of judges are going to say, you killed someone, it's a manslaughter case. We're not going to bother ordering an assessment because nothing that a clinician tells me is going to change my mind. You're not appropriate for a year of treatment and a dismissal or a misdemeanor at the end. Here's the problem. The legislation may order an assessment and compels the judge, if the defense can show some evidence that the person likely has a substance use or mental health issue, the judge has to order the assessment. Let me tell you what Judge Wilson, the chief judge of the state of New York, said about this. He gave testimony at a hearing. I don't believe that our office was invited to that hearing, but he said this part of the legislation will utterly swamp the system and delay connecting defendants with available services. Now, some defense attorneys may say, look, we're not crazy. We're not going to ask on a rape case or a manslaughter case for an assessment. But this is why I have a hard time believing that. If your client has a mental health or a substance use issue and you know that, and they're facing probably some significant jail time, and you do not ask for that assessment, you are facing a potential ineffective assistance of counsel claim on appeal because you really didn't have anything to lose by asking for it. They will ask for it. We have, and this is a great thing, a very zealous defense bar in Manhattan. They will ask for it, and they will take the already very overwhelmed clinicians in our court parts. And I told you, some people are facing months to get assessed. This, coupling the expanding the charges with the must requirement, is going to completely flood the system, as Chief Judge Wilson said. The judge should have the discretion to say, no, I'm not going to order an assessment on this case. Judge Wilson also talked about the pre and post plea model. And I just want to be clear because we didn't get a chance to get into it tonight. In Manhattan, we do a ton of pre-plea dispositions. Almost every misdemeanor. Danielle Mendez, hopefully she's still on. I can't see her in Midtown Community Court. All of those pre-arraignment diversion. You're there, Danielle. Midtown Community Court is almost always a pre-plea model. Pre-plea is often used when the mandates are shorter, right? In most of the Midtown Community Court cases, we're talking 1 to 6 sessions. Some might go up to 12, but they're relatively short mandates. What the legislation is proposing is that essentially on all misdemeanors, all nonviolent felonies, and some violent felonies, the person be allowed to enter treatment dispositions without pleading guilty. As a prosecutor, something that I think most people don't get unless you do this job is that our biggest challenge is often getting witnesses to cooperate. Not because they don't want to see the people who harmed them or offended them held accountable, but our victim population is not that different than our defendant population. Many of them are struggling with housing, untreated substance use and mental health issues. They also have sometimes experienced something very traumatic. We have to bring them down multiple times because the system as it is requires us within 5 days if bail is set to have them come and testify in front of the grand jury. Then they often have to come down again for further, interviews and things like this. If everything becomes a pre-plea model, one of my concerns is that if the person doesn't do well in treatment, the case, and again, as Jeff mentioned, we'd like to give people a lot of chances in treatment. The case, if the person ultimately isn't successful in treatment, what happens to that case is it goes to trial. And we have to try to convince a victim.
So wait. so
Years
they
later-
can't plea if if the treatment is not successful for whatever
Mhm.
reason. They can't plea then?
They can plead, they can choose to plead at
So
any point,
it
but let me
doesn't
ask you,
necessarily go to trial.
but why would any defense attorney, knowing this case is, 3 or 4 years old now?
I think what you're suggesting is, it's harder on the victims because then they have to come and testify. But it seems like I don't know why they would be more likely to have to testify if, like, kind of didn't take, right? Like the treatment didn't take, they did a pre-trial, a pre-plea, but they still have an opportunity. The plea doesn't work, or the treatment doesn't work. They're sort of back where they started, and so they can.
But their case is much older, and here's the
But
thing.
their case is older, and they can still take the plea.
They can, but the defense is going to know that our case gets much weaker with time.
Because you're less likely.
Because
to
the
be able to get
victims, the
victims.
cooperation wanes, the memories wane. I mean, the thought, even if we can get our victim down, they're going to be subjected to cross-examination.
So you basically, you think this is a way that defense attorneys play out the clock?
Yes, and we've seen that a little bit with
Okay.
discovery
No,
reform.
right,
Like, there is
just-
strategy involved, and they're doing their job. I'm not faulting them for
Again,
it.
just.
They're doing their job.
Yes or no question.
I also,
Seriously.
I have to tell you, many victims, one of the ways we get them on board with treatment dispositions is we tell them, the person is gonna, again, these aren't felonies. The person is gonna plead guilty. You're gonna be done with this. And if they're not successful, it will be held to account for that. Victims want closure. I hear that
I understand
constantly.
that.
This is what Judge Wilson says about the pre and post plea model. The chief judge, his testimony. He said, for others, however, he's talking about plea, no plea, a conditional plea upfront will not deter participation and will provide a helpful, even necessary, motivating force to aid the defendant to a successful outcome in treatment. Because the guilty plea, which is always conditional, will be withdrawn or reduced in severity upon completion. A guilty plea can also aid defendants in taking responsibility for their actions, which is a key element of recovery. He also said, while the possibility of a prison sentence may seem draconian to those who are unfamiliar with treatment courts, many participants acknowledge that they would not have been as active in their programming and ultimately successful without knowing that failure could ultimately lead to the imposition of a significant penalty. Moreover, failure and the imposition
You
of
know what would be more efficient is if that slide was on the screen. I bet we can all read faster.
well, I didn't want to,
Okay,
overwhelm it,
we-
but you get the point that Judge
We have
Wilson
the
is trying to
point.
make.
Jeff wants to speak, but I'd like you to just make the other points. That's one of your objections then, is that you prefer prefer a guilty plea rather than a pre-plea.
Not on every case, not on every case.
Okay, what's your next point?
This is a completely unfunded mandate. We already, and Jeff has been at stakeholder meetings with me at the last drug court stakeholder meeting. The entire meeting was talking about how the current treatment landscape is not meeting the needs of our participants. The fact that we are going to flood an already inadequate system with more and more challenging cases without the infrastructure to support it is, I think, at best, irresponsible. There is a long history in this country of passing laws where the
Yes,
infrastructure is not there to support. One of the reasons Rikers and our state prison system is what it is in terms of people living with mental health being there is because we were promised when they deinstitutionalized that there would be a community-based safety net, and it hasn't been. And I'll tell you, I know that Jeff shares the concerns about unfunded mandates because the DA's office recently tried to get some of our partners on board, the Legal Aid
Yes.
Society on board.
My first
Okay,
question
with the
was,
Support Act,
there's not, like, there isn't the, there isn't the support system. We say, like, yeah, put them all into treatment, but like even people with insurance can't get a therapist.
You're absolutely right.
What's the provision in the TCEA that you're objecting to here?
That it's a completely unfunded mandate and that it will take years. And anyone working in treatment courts will tell you to staff up just in terms of social workers.
So how-
The amount of
How
social
would you
workers we
change the
need.
bill?
I would ask my legislators to do more right now before passing this bill to promote supportive housing, ACT teams, IMT teams, residential treatment programs. We need them to be far more, one of the things that came up at the problem solving court stakeholder meeting was language. It's so hard in terms of having providers that speak the languages of our participants. We also need a tremendous amount of scholarship beds. These are beds for individuals who don't have Medicaid because they are not here, they're not documented. And so they cannot benefit. We have to wait for a bed to turn over for them to get access. That is what I would ask. I would ask
I
for.
would say on the unfunded, just sorry to interrupt, on the unfunded mandate portion, we are not asking the state, the governor to sign into law this bill without there being funding. This will be a budget fight. And we understand that. And that's what the coalition in our group has constantly been advocating for. We're advocating for essentially $51 to $52 million for court operations and $75 million for treatment providers. So I don't agree with the whole unfunded mandate idea. Obviously, it's a budget fight. If it doesn't make it into the budget, we understand that no matter what we do, if we pass the legislation in both houses, it'll probably be vetoed by the governor because of that exact issue. So we're well aware of the needs and we are supportive of like supportive housing and all the other funds, but I disagree with the unfunded mandate portion. We are asking for funding in the state budget as we have for the last couple of years. So I just wanted to put that out there for, the community board members.
Okay.
And also, I mean, theoretically, I mean, I know there's a lot of fixed costs involved. It's like fixed costs versus, marginal expense. But if you're putting more people into treatment, like, is treatment really more expensive? When I think about the numbers I hear for the expense of keeping somebody in prison or in jail, like those numbers are insane. I mean, it looks like, makes my lifestyle look cheap. So, maybe it's actually cheaper to have, people.
Yeah. And we
It
totally
is,
agree.
but-
It costs $500,000 a year to incarcerate one person in the New York jail system and 115,000 for a New York prison. So this is also like a cost saving. Well, besides providing treatment to those who really need it, it's also a cost saving measure. It will save New York State so much money. And instead of just pumping out thousands and thousands of dollars to keeping somebody in prison or in jail, we can be using that to provide rehabilitation services. So that's kind of
Okay.
also the approach we're trying to take with TCEA. And obviously, we're still meeting with stakeholders and still meeting with OCA judges to try and get to a consensus. But, that's kind of
And
our
we
whole
want a
goal
consent,
here.
we really do want a consensus too.
Okay, I'm sorry, our committee, our board chair would like to speak. Sandy?
Thank you. I suggest we let Jeffrey speak first. He's had his hand up for a long time. I'll let him go first.
We're just trying to enumerate the objections that the DA has to specific provisions. Do you have any others?
Well, I have to be honest, there are many more and I did not get, I wanted to really do the highest level one,
Well,
so.
we have the issue of the guilty plea up front. There's also a provision that I want to ask you about having a law enforcement officer to monitor.
I'm so glad you raised that.
Well,
Okay, we can go back to it.
we'll
Okay.
get to that. So can we give Jeff an opportunity?
I'm sorry, Stu, maybe I've come late to the discussion, but
No, I think we need to do a little back and forth here. And Jeff has had his hand up and I think he wants to respond and we can go back, but let's, we've got a number of issues that we can address now. So let's hear from Jeff.
First, I want to apologize, Tony. I thought that this was going to be 1 hour. And I have my kids at home and they're probably killing each other. So I'm sorry, they actually really literally are killing each other. So I
Jeff
wanted,
lives in Kings County, so it's not our jurisdiction and
so I wanted to make sure that I could make my points, but it was definitely interrupting you, and I'm very sorry about that, and how that came across. So yes, I would like to respond respectfully. I think that Tony is engaging in a lot of fear mongering and trying to scare you. She's bringing up attempted murder. She's bringing up rape in the second degree. She's bringing up kidnapping, all the kinds of things that the press talks about, all of the worst possible charges that, yes, are eligible offenses under TCEA. I'll tell you right now, it is very unlikely that a judge is going to agree to divert somebody with those charges into a treatment court. And I'll also tell you that the district attorney's office purposely overcharges in the grand jury so that a charge could not be enumerated. So that's also happening. I also want to say that Tony brought up that almost every misdemeanor has pre-plea. It kind of gives off an impression that pre-plea is rampant. It's all over the city, all over Manhattan. It's happening all the time. That's just not true. There is a single court, the Midtown Community Court. Danielle is here. These are low-level quality of life charges, they call it, where people do have an opportunity to have pre-plea. In drug court, the drug court statute actually has a pre-plea provision for exceptional circumstances, meaning immigration consequences. That provision is never used. Judges never use it. Prosecutors never use it. We talked about case lengths. I want to talk about, we talked about how that's going to affect the victims in the case. I'm not a prosecutor, but I will say the case lengths are already over 1 year on average. And I would say that in 97% of felonies, those cases are resolved with a plea anyway. And I would also say the cases are delayed by 18 months during the pandemic. And the acquittal rates were actually lower for those cases that did go to trial. And I would also say that cases almost never go to trial in Manhattan. Actually, 1% of all felonies and 4% of all drug cases, drug felonies and nonviolent felonies are resolved by a trial in Manhattan. So I just want to make sure that we're being honest about what you're saying here, because A, the judges aren't going to take every case, and they don't have to. They're going to go through the public safety analysis. And B, these cases are already taking a long time, and the victims in the cases are already having to deal with that. So that would be my response.
Wait, keep going, Jeff. Let's
Oh,
hear
that's
you.
it. That's it.
Can I respond?
Yeah,
Go save your children.
Yeah, and if I could just add my comments, I'm wondering what we as the community board you're looking for from us. I think this is a very engaging and interesting discussion, but I would like to know how you feel we can influence this issue.
Well, how I feel, I know you heard from Casey, and so it sounded like you were eager to have someone from our office, which I really appreciate, come and share a bit about our practice. I would, what I would really love is for folks, and we've done this a number of times through community partnerships, to come and visit these court parts. I don't think there's anything like seeing them in person, especially the felony ATI part or the drug court. I would really come because I think it's very, very hard to conceptualize exactly what's happening unless you see it with your own eyes.
Totally do that.
Okay, we
Can
can,
you and I.
we can coordinate. We've had folks come from, I can't remember what community board.
It's okay, we'll talk about
Okay.
arranging.
Please.
But I think that's an excellent idea because, we can discuss these issues, but we really want to have something that we can have an impact on and as a community board. And so we totally appreciate you coming to speak with us, but we want to know what we can do. So let's definitely, if we can encourage other members, not just our board members, but people from the community to come, I think that would be great.
Okay,
You're welcome.
Jeff, I just want to go down through a few points. So, Tony would prefer to require a guilty plea up front. Can you express why you don't appreciate that?
I think he might have gone to see his children.
Yeah.
I think she'll find it out.
There's many reasons why the pre-plea model for non-violent charges only mandatory, and for misdemeanor charges only, it's discretionary for for all violent charges, except I think for the few that actually require release under the bail reform laws, if I'm not mistaken. Rocio can correct me on that, but pre-plea, efficiency. This is the top reason. Dropping up the pre-plea requirement is going to fast track and streamline what has historically been an inordinately cumbersome, long admissions process. We know that for Manhattan Mental Health Court, at least by one fairly recent statistic, it was taking up to 1 year to be actually from arrest to admission into the Manhattan Mental Health Court. Access. Pre-plea is going to block access. Pre-plea will block access for non-citizens cannot plead guilty to, or green card holders cannot plead guilty. It's just the mere admission that subjects them to deportation. We're talking about people who are 50 years, 40 years old, who've been living here since they were 2. And they're being treated like they're like, just because they're green card holders, they're criminals. Just by that's what's happening. We're talking about racial equity. Embracing the pre-plea model is a matter of racial equity. We know that the opioid courts they basically benefit a white population, and they don't require a plea of guilty, while their traditional drug counterparts and the traditional mental health counterparts, which are more racially diverse, they all require a plea of guilty. And effectiveness, it's in treatment court settings. And I will say this: at the end of the day, it comes down to readiness of if my client is not. I've had clients that I thought were ready, they weren't ready. I have clients that I thought weren't ready that were ready. Sometimes they surprise me. But at the end of the day, it comes down to the client's readiness and their relationship with their treatment provider that is going to make a difference in how successful they are. So those are
Can
my.
I respond to that?
Take 1 minute for that.
Casey brought it up and Jeff did as well, the opiate overdose courts. These are very low level courts with very short mandates. We are already doing no plea in that space. I'm asking for proportionality. If it is a felony, and again, we allow for no plea diversion on consent and ATI, and the statute allows it in drug court. Just this week, someone who was participating pre-plea because he had immigration, well, I don't want to go into that case, but at the end of the day, there are ways around pleas, even on felonies. But I think on most felonies, and it's not just me, even Judge Wilson's comments, there are benefits to pleas on certain cases. This blanket prohibition, if someone has, and this is not uncommon, 6, 7, 8 bench warrants in their history, 3, 4 pending cases. They've left treatment multiple times during other mandates. This person should not have to plead guilty, and we shouldn't be having some finality there. It's, again, come see.
If a person enters the program without pleading and they drop out, they're back to where they started from. They still have to either plea or they have.
Well, first we have to find them, right? Like a lot of these folks who leave treatment
Well,
go out
that's
on
true,
bench
even if
warrants.
they plead guilty or not,
Well,
all right?
Not necessarily, but because if you're in a post plea posture, you know, at least on these very serious felonies, may likely be incarcerated because bail is eligible. Those are bail eligible offenses. So first we would have to locate them, return them to court, and then we would have to assess, is our case, can we still proceed on this case? Do we still have a victim that we can get in touch with who's willing to come down and cooperate in the prosecution? So I would say that without a plea of guilty, a defendant is in a much better strategic position to challenge the case.
And I'll ask you both, if someone has to plead guilty in order to get into the program, won't that discourage a number of people from entering in the first place?
Yeah.
Well, you know, at the end of the day, this is not a get out of, trouble free card. Like you committed a crime and you're willing to say, I committed the crime because I have these needs that I'm willing to address. And so I'm gonna plead guilty and I'm gonna.
It's a disincentive.
But should you be able to at any cost, okay, I'm gonna try treatment court. If that doesn't work, then I'm gonna take my case to trial. Like, honestly, part of being in treatment court, and again, Judge Wilson alludes to this, is acknowledging that I did something wrong. I harmed, a person, my community, whatever it is. And again, I'm just asking for proportionality. For
Okay,
most
let's-
misdemeanors, I think we
let's
can
hear-
agree.
Excuse me, it's 8:30. Jeff has indicated that he has kids and that, and that he'd like to talk to them. I think we could do this all night. I think if we wanted to, we could do this all night, and we could do it tomorrow. We can continue this conversation. You asked earlier, what can you do? Tony gave a suggestion. We can bring everyone down to the courthouse. We do court tours.
Well,
We can go to the park. I think it would be a good time
Yeah.
to make our final points. I know you gave Tony a minute.
Well, what
Maybe-
I'd like
maybe one
actually to
minute.
ask you both is, could we send you some written questions to which you would be willing to respond?
Sure,
Jeff is nodding yes.
sure.
Well, I would love to. I have supervisors and, who obviously dictate ultimately what we can put in writing and how we can respond to what, but send them along and,
I mean, I won't look at.
yes, someone will
They're much-
hopefully allow us to.
Okay, but I do, I just want to hit a couple of points quickly. Jeff, one of Tony's points was that, was about who could modify the treatment plan. And the question was, does the judge have to approve it? Just make the case very quickly that the judge, you don't think that the judge should have to approve a change in the treatment plan, is that right?
Well, right now, the judge and the prosecutor throughout New York State are play a huge role in the treatment plan. They play a huge role. So what we're trying to do is shift that from allowing clinicians, and I'm not, here in New York City, we are more progressive. I'm not saying that's not the case, but what we want to do is we want to shift, we want to take, not let lawyers make decisions about treatment plans. The judge is a lawyer. I'm a lawyer. The prosecutor's a lawyer. And allow psychologists, like licensed clinical social workers, CASAC, you name it, CASAC.
Well,
And let them, and then they make the recommendation. The judge is the judge. The judge can reject it. The judge is the judge. But what this bill does is it makes it very, very clear that the clinicians are going to be leading the way with treatment plans. They are leading the way. And that is the change that we need.
in a court, judges are not experts on science, for instance, or medicine. You have
Sure.
standards by which a
Absolutely.
judge or jury still makes a decision after being informed by the experts. Isn't that appropriate here?
Are you asking me?
I am, yeah. Isn't it appropriate that the clinician make a decision, but then has to persuade the court,
The judge, yeah.
the judge?
I mean, the judge is the judge, and the judge is always going to make a decision. Like it or not, no matter, they're going to make a decision. But what this bill does is it encourages that our clients have peers. It encourages that we no longer rely on an abstinence-only model, and we rely on clinicians who are familiar with our clients' complete mental health, substance use history to make those decisions. And it's the same thing here with the clinical recommendations. They have looked at all of the records that Tony is going through and her deputies are going through, sifting through those records, looking for public safety concerns. And we're now going to let the clinicians look at all the records. They're going to put in their clinical report all the information. All the information is going to be there about the person's history, about whatever they've done in the past that could be a public safety concern. They can, do a violence risk assessment if that's what the judge asks for. And at the end of the day, they will make the treatment recommendation and the judge should follow that.
Okay, sorry, Sandy, I think is looking at the clock, so let's see what.
I am. I'd like to thank everyone for coming and, let's call this a very robust discussion and follow up later, but I really think that this is, if we know how we want to move forward, we should probably move on.
Well, I think we have, probably 6 areas of disagreement. My count may be off.
Yes, lucky for you that you're doing the minutes.
Oh,
So,
my.
I mean, our disagreements, we can follow up on, but I don't think we need to, we're obviously not going to be able to resolve them this evening.
Okay, Jeff, do you want to make any closing remark?
First, I want to thank you all for having me today. And I do think that the Tony and her colleagues and DA Bragg and the Legal Aid Society in the Bronx and all the defenders, like we do share a goal. Actually, we share many goals. We share the goal of public safety, believe it or not, but we believe that public safety is best achieved by not exposing our clients to incarceration, to prison, to being discharged into homeless shelters without any supports, and continuing that revolving door. I believe that the Pathways Unit in Manhattan DA's office cares very, very much about improving the health of our clients and that is linked to the public safety. We agree on that. I just think that we have different opinions on how we're going to get there. So I do thank you all for having me. I think it was definitely a robust conversation. I've never done anything like this before. So thank you for having me. And
We feel bad about your kids, and we hope they survive.
my son is texting me to accept a Roblox over and over Roblox. Like he's texting me $2.99, please.
But you know what?
At least he's on games. That's a good thing.
Yeah, maybe it'll make them work it out, right? Lock them in a room, make them work it out. That's what my parents did.
Okay,
Thank you all.
And we both survived.
so I think the way we will conclude this is we will provide written questions to both of you. They may be different questions, but you'll each see what question we're sending to each of you. And if you can respond in writing, that would probably be most efficient. Are we all good with that?
Works for me.
Yeah, and I think we understand the bill and we understand the concerns and we understand where the disagreements
Yeah.
are. That's
I think-
what's important.
I'm not sure if Senator Ramos's rep is still here, if there's anything she wanted to add.
Say again.
No,
I'm
I
sorry.
think I concur with everything Jeff says, and I appreciate Tony coming. I hope we can still keep this line of communication and collaboration open to, hopefully come to a consensus. But I appreciate all the community board members for, taking this very long time to, really have this conversation. And, we hope to, continue having this conversation and coming to a consensus. So thank you.
And I do think we should take you up on visiting the court to
Yeah.
see exactly what's happening. As you said, that's the best way to know what's really going
Right.
on. Thank you.
Jeff is still with us. Would you sometimes come along with us if we did this?
I 100% agree with Tony, and visiting these courts is great. It's actually really wonderful to see what's happening in these courts. It really is. The judges are very engaged. They treat our clients like human beings. They have conversations with them. They remember what was discussed on the last court date. It's a whole completely different experience than the traditional courtroom. And I do think that the treatment courts in our city should be very proud of themselves for what's been put in place. And we are appreciative of the Manhattan DA's office for the number of people who are being diverted compared to DA Bragg's predecessor. But I absolutely agree that you should visit these courts, 100%.
And I do remember the chief administrative judge, whose name just escaped, Zayas, had spoken about having certain judges in these courts with the right temperament. In other words, not every judge can be randomly assigned to a treatment court. So,
Would Tony be able to give a final thought as Jeff was able to a
Yes.
few times?
yes, we're getting there.
Sorry.
You don't have to project her. She's doing great.
That wasn't that.
Keep that. That's very cute.
Thanks.
Yeah.
So we've heard from Jeff, we've heard from, Rocio. We hear from you.
Well, I'll just say, as Jeff did, thank you so much. We love even getting out to community and sharing what we're doing. Very excited to welcome you to our treatment courts whenever is convenient. I think that there is probably several things that we could agree on tomorrow that would improve practice, expand eligibility in a reasonable, common sense way. And I certainly hope that we can find a place of agreement and get some movement on this. And I would just really implore everyone to, as this works its way through, to, including Senator Ramos's office, to do everything you can to support community-based treatment and housing, because in an ideal world, people would not get rearrested or would not cause harm, get rearrested in order to get the help and support they need. If we can provide it in community, especially things like supportive housing, I think on the front end, people wouldn't be harmed, with the degree that they are. And there's no reason to wait for this legislation to make the investments that are so desperately needed. So, Jeff, always a pleasure. I'm so sure I'll see you tomorrow.
I hope you don't hate me, Tony.
No, well, let me say, and everyone please also think of my husband who's with my children.
All right. Yes, I will see you tomorrow.
But thank you very much.
Thank you all.
Yeah.
We're just gonna move, is there any old or new business?
There's something that I'm just gonna say like 2 words, because I'm just curious if either of you guys, any of you here wanna weigh in, is an issue that came up last time, we haven't followed up on, but domestic violence, which it has come up since last month in kind of random ways that I've been hearing about this as an issue that is not decreasing in New York. And if either of you, I'll maybe just put that in one of my questions. But if there's things that we can do, things that we should do to learn more about it, and kind of what's happening and the things we might be able to do to address it as a problem. But since you are here from people that are interacting with that situation.
Yeah.
Right?
Yeah, I mean, it's a very serious problem, and certainly we see it more than anyone would like. I think that, Sherman, does the DA's office have a domestic violence kind of presentation, community partnerships presentation?
I actually just texted and asked right now, because I don't know off the top of my head.
If not, for what it's worth, we could certainly bring someone who works in
Yeah,
that
it's-
practice,
We do.
Okay,
Yes, we do, and we actually have a link, I will send it to Stu. It has all of our educational offerings. You can make a request for a presentation, and we will come give a
Right,
presentation.
because I think 8 years ago, I wanna say, we sort of learned something about it, but my understanding is that it's one of the serious crimes that has not
gone down.
gone down. And, so, it's on public safety, right?
Absolutely, yeah.
We get a lot, I mean, we get a lot of the victims of domestic violence calling us saying, what can you do something to help my husband? Can you do something to help my partner? And I do know, I mean, I'm not a prosecutor, but I know that I imagine that puts a prosecutor in a very tough spot. Because there could be all kinds of reasons why it's a psychological issue, and I really would defer to Tony to talk about all of that. It is very complicated, but I guess the point I'm saying is that the people who are arrested for those charges too have their own host of problems, and I do think that the best way to prevent those problems from reoccurring is to get them the help they need. We don't see very many domestic violence cases in treatment courts. I just want to be clear about that. We just don't.
Eve, I know you're under the weather, but we want to give you an opportunity to make sound if you wish. You don't, okay.
Or maybe can't.
I will just say to that point about the questions about domestic violence, as I mentioned at the end of the last meeting, one of the arms of our office, the Survivor Services Bureau, so like the Pathways to Public Safety Division, so it's a large entity in our office, just to show that we take it very seriously. Work with a lot of victims of domestic violence, and so those are advocates and clinicians who work with survivors. So anyone who's been the victim of a crime, not anyone, but like most folks who have been the victim of a crime are eligible for these services from our office, whether that's needing to move housing, if that situation has come up, or needing access to a counselor, and all those services are free. And those are wraparound services from Matia's office.
And I'll just say, you know, we do refer them to folks charged with domestic violence to treatment. There are some, you know, there is treatment available, abusive partner intervention programs, et cetera. I will say that many of the defendants we see committing domestic violence or other crimes often grew up in homes where there is domestic violence. So,
Learn.
yeah.
Hurt people hurt, right?
Yeah, exactly.
Can I just say for the record here,
Of course.
just to put it out there, the fact that we have so many people with drug addiction and mental illness is really a reflection of society failing most people.
Absolutely.
And I just think, you know, senators and people in elected offices, we need to create a better society overall, because even all the work that's going on in treatment courts, they're still
Yeah.
going back to those societies, this society. So I just wanted to put it out there because it's a, you know, we all are affected by this and we can be better.
I think Rocio would probably say that if we could just move all this money from prison to treatment, then we could treat people even before they get involved in the criminal adjudication.
Although
Or have them
the
living in better neighborhoods, or access to healthcare,
Or
or
better
access to
just housing.
But we
Yeah.
could all be asking, because the Rikers population has gone down significantly in the last few decades, if you look at that curve. I would ask, where did that money go? Where did it go?
That's a good
Yeah.
question.
Where did it go?
Yeah. But, and at the same time, everybody wants to close Rikers, but
Thanks, Jeff.
nobody wants
Oh,
to.
bye, Jeff.
Bye, Jeff.
See you later.
I think first of all, we can close the meeting and we can have this discussion afterwards, if anyone wants. So, would somebody like to move
I will move
Motion
it.
to adjourn.
without objection?
Without objection.
Adjourned.
Sure.
Dinner.
I really appreciate your passion.
Thank you.
Brendan.
I mean, it's clear that you are, like you're a lawyer.